All right, everybody, we're going to get started up. Thank you so much for joining us for this research series event. I'm absolutely thrilled to welcome Professor Matt Malone, who just joined us this last summer, and he's going to be giving a presentation on some of the things that he finds really interesting. Just as a little bit of a background to him, because you may not know him. He comes from, well, he did his first law degree at McGill, and I did some of my graduate work there. So we're already deeply connected as McGillians at heart. And so he also has degrees from the U of T, from Hebrew University of Jerusalem, and as I already mentioned, his law degree from McGill. He's currently working on his PhD at the University of Ottawa. Before coming to us, he used to practice law in California. And he did, I don't understand the full scope of it, and maybe some of that will come into this, but he did some investigations into companies in the labor employment division of a large law firm. So I'm sure that he'll talk a little bit more about why he became interested in what he's presenting on, and maybe it connects to that. His research interests now, though, focus more on trade secrets and confidential information. Now that he's here, he's working on this stuff, and he's also teaching courses in civil procedure and fundamental legal skills. And there'll be other things I'm sure they'll be coming up in the next couple of years. But anyway, I'm just very excited to have Matt, who's a wonderful person, a new addition to our faculty here, sharing some of his work on Canada's Access to Information and Privacy Act. So before we clap, I just want to let you know that because we will, is that we want this to be sort of like a more relaxed conversational kind of presentation, right? So Matt is going to introduce some of his own work and talk about the structure of these acts, and so we can know something about what's interesting about them. He's going to explain how they could be potentially relevant to some of the work we do by talking about some of the uses that he's put to it in his own work. And then he's going to actually go through something that we haven't done yet, which is like more of a workshop. He's actually going to walk us through looking at some of I don't know if he'll look at exactly the legislation, but the website, some of the government websites. He'll give us some tips on how to actually use some of the tools that are available to us. So I think it could be a really, really exciting learning opportunity for all of us as well. Anyway, so that's why I'm so excited about today, because it's a little bit different. Feel free to interject if you have questions. I'll be interjecting as well. But Matt just wanted, he said this earlier, he wanted this to be something where we could feel a little bit less formal and we could kind of be more conversational. So please feel free to kind of interrupt if there's a question you want clarification or some more background. That's more than welcome for today. Okay, without further ado, please join me in welcoming Matt. So just to reformalize, after I said we should be informal, right?
Right. Well, thank you very much for the intro. And today, what I really want to do is kind of just provide a little bit of context and then give some practical skills to the extent that it's helpful to you. The Access to Information and Privacy Act frameworks are sort of a hobby area for me. I got into them a bit accidentally, but I spend quite a bit of time on them, and probably an hour or 2 hours a day. And I think that they're actually really important. Whether you become a litigator and you make use of these frameworks in advancing the interests of your client, and there's lots of great examples where the access to information system is doing that. And one example that comes to mind is the class action regarding Black civil servants, where data collected through the access to information system is fueling that class action. Or if you're an activist and you're committed to a certain cause and you want to use the system to acquire information that belongs to or is under the control of the government, it's also a good way to do it. And if you're doing research as well, I think the framework is really powerful. So I'm a strong advocate for learning how to use it. Today, I want to just sort of start by saying I'm going to talk only about federal access to information and privacy with a particular focus on access to information. Every jurisdiction in Canada has a framework covering access to information and privacy, but they're all, because it's a rather Byzantine framework or Byzantine legislation in each of the jurisdictions. I just want to focus on one jurisdiction, and that'll be the federal one, just for convenience. so to talk a little, and just to echo Blair's comment, I do encourage, if you have questions and you want to jump in, please do. I'm super receptive to that. But maybe I'll explain how I got into this area of research. And it really happened after I was working as a litigator in California, where a lot of my cases were employment cases that had a trade secrets element. And so when I decided to go to grad school, I focused my research on trade secrets and confidential information. And there are not a lot of areas in Canadian law where trade secrets and confidential information are captured in statutes. Right? It's not a really legislated area of law. But one area where we see trade secrets and confidential information pop up frequently is in the context of access to information. And I was really fascinated by this because traditional situations in which you see notions of trade secrecy and protection of confidential information emerging are in private settings. Like the most traditional one's probably a departing employee who's walking out the door with confidential or very valuable information. It's a very common situation in which these notions sort of will be engaged. But it doesn't really find itself in the statute, but somehow they were imported into the Access to Information Act, even though they sort of emerged from private law. So this was really interesting to me. So I started to do some research on how often justifications of trade secrecy or confidential information are being used to block the disclosure of information belonging to or out of the possession of the government. And I did some quantitative research on that and found that a few departments were using them a lot. And specific departments like Innovation, Science and Economic Development Canada, which is responsible for Canada's, the Pan-Canadian AI strategy, so Canada's artificial intelligence strategy. And they use these justifications in basically a quarter of all the requests that they respond to, which struck me as really high. And another entity that I looked at was Public Services and Procurement Canada, which is responsible for liaising with third parties to procure goods and services that the government will then utilize in its own function and operation. And the same justifications were being used to block the disclosure of information that was government information or that the government had under its possession. 3 years ago, it was 40% of cases. 2 years ago, it was 45% of cases. And 2 years ago, or last year, it was 60% of cases. So there's this enormous rise in recourse to these justifications to block the disclosure of information. And I've seen that in a bunch of other contexts. I've seen that in the context of the COVID-19 vaccine contracts, where really basic information about these contracts, like the governing law for the contract, the IP provisions, and sort of similar, really basic parts of the contract were being withheld from disclosure on the basis of justifications that were connected to areas that I was studying. So I got really interested in this and thought, why isn't anyone challenging this? What's going on with this? And sort of another institution that is well known is the Trans Mountain Corporation, which uses these justifications basically to block disclosure of everything it has. This sort of came to a head for me last summer when my interest in the topic sort of found a live subject, as it were, when sort of some of the controversy started to emerge with the ArriveCan app, because the ArriveCan app was contracted to third parties. It used automated decision-making and artificial intelligence in its decision-making that wasn't reviewable, that wasn't subject to review. And so I started to file access to information requests with the intention of challenging them when I got rejected requests. So I started filing dozens of requests for things like, give me the source code of the app, give me records of cyber due diligence that's been done for the app, give me bug reports, give me all the validation studies. I just strategically started hitting them with a lot of access to information requests. And I got all of these rejections. And so I started filing all of these complaints. And it was a really interesting experience for me because the more I sort of tugged on it, the more I began to interact with the ATIP officers who were processing my requests and realizing if I was shaping my request just a little bit, I might be able to get a little morsel here or a little morsel here. And so that was really interesting for me. So the ArriveCan app, and I wrote about this experience in an article just talking about the interrelations between access to information and access to justice in that particular episode. So that was another instance in which I found the use of the framework really exciting. I can mention just a couple others because what I'm trying to do is kind of illustrate how I've been using the system and how I've found it kind of interesting to tweak with. So the mandate letters dispute, which is currently pending before the Supreme Court of Canada, is a dispute between the CBC and the Ford government over the Ford government's refusal to disclose the mandate letters that Premier Ford gave to his ministers following the 2018 provincial election in Ontario. So he refused to disclose it under an exemption in Ontario's Access to Information Act for cabinet records. Cabinet records can't be disclosed if they reveal deliberations of cabinet. And so CBC, in its filings in the lower courts and currently before the Supreme Court, has made all of these very grandiose statements about access delayed, is access denied, and all these other things, and the perils of an impoverished access to information system. And they started publishing a few pieces as well about their ATIPs to the Ford government that were really interesting, that were like, the Ford government has refused to disclose the number of hours that its lawyers are spending on this lawsuit. So I got really fascinated by this, and I decided to troll the CBC, and I copied the language and sent these requests to CBC. And I said, tell me the number of hours that your lawyers are spending on and in the CBC article, they said, well, the Ford government says that this is privileged information. There's no way that just the hours are privileged, right? As the law students will quickly find out, your bills may or may not be discoverable, and hours certainly won't be subject to privilege. But it was kind of interesting. So I put the question to CBC and I said, give me the number of hours. And they said, well, we can't give you this. This is privileged information. I was like sending them their own articles, and they were like, you could see the ATIP officers just be like, and so finally they started to disclose some of the information as I started to play them off one another. And I went back to the Ontario government. I said, well, now CBC has disclosed its hours. I felt like some sort of data broker. And I wrote about this as well. And it was a really interesting experience because I wanted to quantify how I think what the real issues are in access to information, which are operational issues. When you make a request for access to information, the real issues are, is the request being timely responded to, right? Is there a timely response? Are you getting disclosure, meaningful disclosure? Are they meaningfully searching for the record? Are they actually making the record available? Are they redacting parts of the record? So those operational things have really undercut the system. And so it was kind of interesting to sort of make some comments on that. A few other areas that I'm currently just sort of plugging away on are, I've been doing a lot of access to information requests with the Canadian Transportation Agency, just to get information from them. And, there's a lot more. So yeah, these are sort of ways in which it's been relevant to my own research and just as a hobby. Yeah. Yeah.
So why don't we kind of like take a step back then and talk a little bit more about the rights that are embedded in the legislation for access to information. So what can we actually ask for in these acts?
So the Access to Information Act and the Privacy Act, federal legislation, they both say early in the legislation to whom they apply. So they apply to federal institutions. They also identify their purpose, which is important to take to sort of think about in the broader context here. So the Access to Information Act says very clearly its overarching goal is accountability and transparency to foster public debate and to enhance democracy. And I think that's a really interesting purpose for the legislation that I often try to remind the ATIP officers about. I firmly believe that meaningful access to information is probably the most important way to, and there's an example that kind of immediately comes to mind, which is this current conversation we're having about election interference, right? A lot of the anxiety that's felt in sort of the media reports around alleged or purported election interference stems from the fact that we don't really have access to any of the information that's being referred to, right? There's sort of illusions about it. There are illusions that it wasn't revealed or shared in a timely manner. So I firmly believe that the purpose of the act is important in combating things like disinformation and malinformation and a misinformed public and so forth. The Privacy Act has a very similar type of objective, which is to make a right of access for individuals, for all of you whose personal information is in the possession of the government. So you have the right under the Privacy Act to go ask federal institutions that are covered by the Act for your personal records, which is something that can take a long time to do. So they both create a right of access, but what the interesting thing between them is that there's almost it's odd to put them in one group. Like we refer to them as ATIP, access to information and privacy, but it's weird that they sort of go together because access to information is really about disclosing records and making records available. And privacy, we tend to think of not disclosing and sort of keeping records shielded from disclosure. So there's this sort of interesting duality between the two of them, and that tension between the public interest around disclosure and the public interest against disclosure are something that really inform how the system operates. But the most important right that they contain is a right to access this information. So the Access to Information Act, I believe, there's about 250 institutions that run an access to information unit. So a lot of and I'm kind of curious, I'll pose a question to everyone in a second, but a lot of the big actors will have their own access to information unit. And then some of the smaller actors will sort of pool their resources and share ATIP officers. But I'm kind of curious, I'll just kind of ask who you think has the biggest access to information group? Like who fields the most access to information requests in the federal government? Maybe that's the way I'll ask it. Who fields the most access to information requests in the federal government? Yeah. So that's a really good guess, and I wish it could be true. For the simple reason that the PMO is not covered by the Access to Information Act. And there are a few specific, and this is a subject of much critique, there are a few specific entities that are not covered by the Access to Information Act, and it's become a huge problem. And the Prime Minister's office is one of them. Another one is the actual offices of ministers who run various departments. So their departments are subject to the Act. All the civil servants are subject to the Act, but the ministers themselves and sort of the 30 people around them who are making really important decisions are not. So it's actually, yeah. I'm curious if anyone has any guesses, any other guesses? That's a really good guess. They're towards the top, but the Canadian Revenue Agency is not the top. It's actually, and it's by a wide margin, it's Immigration, Refugee and Citizenship Canada. And it's for a very simple reason. And they actually field 80% of all requests. So and 10 years ago, it was about 40%, but it's skyrocketed. So they now field 80% of all requests. And for the simple reason that the rights that are under the Access to Information Act and the Privacy Act only extend to Canadian citizens and permanent residents. And so individuals who are trying to seek status in Canada, but who don't have that status or who are outside of Canada, and if you're a permanent resident or citizen who's located outside of Canada, one of the ways in which they'll delay you in an access to information request is to seek proof of your identity. And it's kind of an interesting and frankly a bit sketchy the way they do it. But it's really Immigration, Refugee and Citizenship Canada is the main destination for filing access to information requests, because it's usually representatives, attorneys who are seeking information about their clients who don't have a right of access under the Act. And so a lot of those cases just backlog the system. And I think, I'm not remembering the statistic off the top of my head, but it's somewhere in the area of about 40% of those requests are actually met in a timely manner. Yeah. So let me,
I was going to ask, so once, there's several different kinds of questions we could ask, but once the request is made, what happens next?
So when you make a request under the Access to Information Act, there's an obligation on the part of the government to respond to you within 30 days. So the framing of that obligation is you have to make it in 30 days, or you have to provide notice of a delay. And the delay can be justified in two ways. One is that, meeting or responding to the access to information request would interfere with government operations. And the other one is that consultations with other departments in the federal government are required in order to respond. And so when you file, or they just lose your request. And so it happens all the time.
Sure it does.
So when you submit your request, right, you should immediately be tracking what's happening with it, when you filed it, and when that 30-day period comes up, right? Because what will happen is, and they will come back at you and try to extend your request, but they're only allowed to do it once. So what happens is you file your request, and here is where I just want to like show you guys how to use the system because it gets kind of interesting.
Can everybody see the screen okay? Yeah.
Oh, wait. So if you go to the online request tool, this tool will cover a lot of entities in the federal government, but it doesn't cover all of them. They're trying to streamline it as much as possible. You'll click through, you'll sign your rights away on a privacy notice that you won't read. But once you submit it, you'll get a confirmation. The government needs to acknowledge receipt of your access to information request. So for example, I put in a request last week for a list of government entities that have been the subject of ransomware attacks in the last 3 years. So I put in the request to the Privacy Commissioner, which is the entity that would receive these notifications from other entities in the federal government. So you immediately get a confirmation that your receipt has gone out, and then you get a notice from them saying, we are in receipt of your request, and we will start processing it now. There are many government institutions that will delay that part as much as possible, because that's what triggers the start of the 30-day period. So entities like the RCMP are notorious for receiving your request and not responding to it for a very long time. If things like that happen, I strongly encourage you to think about the complaint system. And so this is sort of the other side of it is when you make an access to information request, you should always be thinking about complaints. I mean, that sounds a little silly, but like it's true because it's often the best way to sort of push the entity to actually get what you want, because there's this ingrained culture in so many of these ATIP units against disclosing information. And so basically, whenever you engage with the system, you should be thinking about complaints. If you file the request and you don't get a response, you should complain. If you file a request and you get a notice that it's going to take 375 days to respond to your request, which regularly happens, you should file a complaint. And the reason why you should file a complaint, if you get your request and your request is redacted for whatever reason, and there's several different types of redactions and exemptions in the Act, you should complain, right? And as lawyers or folks educated in law, you're uniquely situated to file these complaints. There's no real like jurisprudence around how the Office of the Information Commissioner responds to these complaints. Under the Act, the Office of the Information Commissioner is responsible for processing the complaints, and they're pretty simple to file. So if you go to their website, they make it very prominent how to submit a complaint. And all it is a one-page PDF form, and you just email them. And it's very simple. You just fill out your justification for why you believe that they're not meeting your request. And one of the reasons why I think folks who are sort of trained in the law are really well equipped to do this is that the government has so much guidance in terms of how the access to information system should operate, right? It's not really reflective of how it actually operates, but it's how it should operate. The Treasury Board Secretariat has policies regarding principles. They have like the Noahide laws, right? Like principles for assisting requesters, right? And they say things like, timely follow-up and things like this. So invoking these, no one, I've spoken with many journalists who filed complaints, and I see their complaints and they never have these things. And I always put these things in, and I'm like, principle number 1 says, and then there's this huge access to information manual that the Treasury Board Secretariat publishes, which explains in great detail, and it cites all of the cases that have been the subject of judicial review and so forth, very detailed discussions around what each of the exemptions is, what each of the standards are. And if you just hammer away on some of that and throw the legalese at them, it sometimes works. I've been very successful with my complaints, and seeing that has made me realize how many folks have filed complaints or sort of filed requests, received sort of a fully redacted response, and then let it sort of fall by the wayside. So it's been absolutely stunning to see that. The one thing I would say is there's a project I've been working on for a long time. So anyway, I guess I should shift, because I'm like, yeah, Rob, yeah, go ahead.
So it's sort of analogous to tax. Like you file your taxes, CRA takes the position as, this is not a valid example of deduction or whatever, or credit. And then if you disagree, you go to court. So I was unclear about this. So when you ask for information, the entity takes the position that you're not entitled, but that this paragraph of this document falls under some exemption, justification for us not to disclose it. You file a complaint, but the complaint, the office of the
Information Commissioner.
Yeah, is not quite like tax court, or is it? So you file your complaint, and then does you stop there? Can you explain sort of like the process? And if you disagree with the position of the commissioner, what then happens?
Yeah.
Judicial review, like how does it work?
Yeah, it's a great question. So recent amendments to the act that were made in 2018 actually allow the information commissioner, they give the commissioner order making power. And they also give the commissioner the ability to publish their decisions. So prior to 2018, there were no published information commissioner decisions regarding how the act was actually being enforced. So there was a whole body of jurisprudence from the information commissioner that was just invisible. And so that was not available to complainants. It was not available to institutions to sort of set standards around, create some sense of certainty around what the actual interpretations and enforcement practices were. And what happens when you file a complaint with the information commissioner, say, I filed with Innovation Science and Economic Development Canada for something pertaining to the pan-Canadian AI strategy, they redact something as third-party information. When the information commissioner gets the complaint, they will receive, because of their order-making power, they will receive a copy of the unredacted version and the redacted version, and they'll be able to examine the record. And so you can actually get on the phone with them, the information commissioner or your investigator, and they will actually explain to you and say, the government's claiming solicitor client, like a privilege of some kind, and this is privileged. So, and I personally find that tends to be enough for me. When I get to that level of the complaint, I will normally stop and realize I'm not going to get anything. I put in so many requests for the around the Emergencies Act, entities like public safety and so forth, where I would get like one document, or I'd get, even though it was so clear that there were more documents. And with those types of situations, including after an investigation that sort of pulls up nothing, you can seek judicial review. But I haven't gone that far yet in my own complaining, just because of resources. But I think there's a lot of, one of the challenges that we've seen is, even before you get to that process, there's been a practice emerging in the access to information system where federal government institutions will actually bring judicial review against the Office of the Information Commissioner. And that's happened a few times in the last year to 2 years. Yeah.
But generally, the commissioner just, they agree with you. They just tell me, no, you've got to.
They have order making power, so they can actually order the disclosure of the record in a certain way. Yeah. Sorry, Chris.
Oh, no, I was just going to ask if you could just ATIP the jurisprudence that they had previously published.
Right. I mean, and that's all, like ATIPing ATIP is really fun, because sometimes when they really stymie your request, there's a reporter at the Globe named Chris Hanna, who has filed a lot of ATIPs to Export Development Canada around a loan that Export Development Canada gave to two gentlemen in South Africa who were in a close relationship with Jacob Zuma. And they used the loan to purchase a Bombardier jet. That was sort of a condition of the loan. And essentially the jet went missing. So he's been running this like 5-year investigation. Where is the jet? Its tail has been scrubbed and all this other sort of stuff. And Export Development Canada is one of the worst entities for actually disclosing records. If you look at sort of a lot of entities that you might think don't disclose records, like our national security and intelligence agencies like CSIS or CSE, are actually pretty good in responding to, I mean, if there's a national security interest and they invoke that exemption, they won't give it to you. But for the most part, they're actually pretty good in responding to requests, doing so in a timely manner. Export Development Canada is not. And so what he's done is he's become the master of ATIPing his ATIP. So he's like, give me all records about my ATIP request to you, including correspondence, reports, internal messages, and so forth. And so really interesting stuff there. Yeah.
So, Oh, sorry, there's another question.
Oh, sorry, yeah. These are great, by the way. Yeah.
Just based on the ministries and departments you're talking about that are using sort of the defense of innovation and other trade secrets sort of like guards, have you seen that trend more generally that, like, I'm wondering on their side, do they just have buckets of information they're going to go, we can cover this pretty consistently, and not with saying this heading or this privacy function is basically going to guard against a journalist or professor engaging in this kind of research, and sort of almost just by default saying that's just that area? Or is it sort of more like, is there more curation from an actual, like, it sounds like there's at least initially a shield that goes up that says you can't look into this, and if you dig far enough, then you kind of can hold them accountable to that not being the right mechanism. But I'm just interested to know whether you're seeing the trend go up because there are more people kind of trying to file up maybe in a less good faith way versus like people who honestly want to know more information, but then are just sort of reaching through stonewall points.
It's a really good question. And I think the interaction between sort of, I think viewing sort of the tension between sort of the substantive purpose of what access to information does, because we don't have protections. There's no right to information in the Constitution. There's no, like, the most you'll get is sort of enunciations, really beautiful enunciations in, you know, jurisprudence from the courts, but we don't have a fundamental right to this information. What we have instead are sort of these procedural rights that are articulated in the way that the access to information system enables us to seek information from the government. And my personal view is that those are neutral, like a lot of procedural devices. And so reading into the request is interesting because the access to information system collects at a granular level, it collects information for who the requester is if they want to disclose it. If it's a business, if it's media, if it's an academic, if it's a member of the general public. And certain departments in the federal government are more commonly sought after by certain of those groups, right? For example, I can think of Global Affairs Canada, which is, and Department of Finance, which are, you know, sort of main targets for media requests from the media. But there's no obligation to disclose that you are in fact any of those things. And one of the principles for assisting requesters is that the government should be agnostic about who you are. They don't sort of bandy your personal information when they're seeking the request. So, for example, if I were to put in a request with the Treasury Board Secretariat, they wipe my personal information. So no one knows that it's me putting in the request unless it's obvious from some other respect. Yeah. The one thing I would say, and this interacts with a project that I've been working on for a bit of time, is, well, I think, actually, I want to make one more comment and then I'll go to that. But just in response to what you said, because I think it's important. I mean, there's almost a sort of captive relationship between the party who has the information and the party who's seeking the information. And sort of as you've alluded to, there's a bit of a dance between them, right? There's always going to be ways where, you know, parties who start requesting information and the other party, the party that is requested, is going to sort of find ways to sort of dance around that, right? And that's happened very often in access to information. So you see things like the government has an obligation to publish briefing titles. That's a new obligation. So on the Open Canada website, they publish briefing titles that the ministers will get, or that deputy ministers will get. And a very common type of access to information request that people will file is the actual briefing notes themselves, because the government only has an obligation to publish the title. But one thing that you often see happening is that the government will, or certain government entities, and especially in the national defense and sort of security sectors, will sort of use code names or kind of change things in the briefing titles to try to sort of skewer the requesters and sort of mislead them. So you see things like that, which are really egregious. And the other space in which you see this problem come up is in the way people decide not to document information. And this is really probably the most illustrative example of that dance. One way to avoid an embarrassing access to information disclosure is to not put anything on paper, right? I remember that seems pretty obvious, right? I remember when I started in a law firm someone said to me, you know, and I've heard this in many other contexts, you know, don't put anything in writing that you don't want to be disclosed on the front page of the New York Times. And for some of our clients, you know, that's like something you would take very, very seriously. So those sorts of, and I think it's ingrained in a lot of government institutions, this fear of sort of the smoking gun, you know, because the access to information system has played such a central role in creating accountability, right? For those who are old enough to remember the sponsorship scandal, that began with a very simple access to information request by a Globe and Mail reporter to the Public Works Ministry for an audit regarding what it was spending on advertisements. So it was a very innocuous sort of access to information request that created this thread that just revealed this massive sort of billion-dollar scandal and how money was being misspent. So it has rendered accountable government in so many ways. But because of the fear of that accountability, or because of the fear of sort of what it could do to your either civil servant or political career, it often activates this unwillingness to actually document information. And so you increasingly see, especially with new technology and things like messaging apps that allow messages to sort of dissolve or disappear after a certain amount of time, or even holding, you know, let's shift to a conversation, right? Like, and I'm guilty of that when I was in practice. Like, whenever I didn't want something to be in writing, I'd be like, hey, why don't we have a quick phone call? And it's like, because the thing is embarrassing and neither of us want this to be in writing, which lives forever, versus a conversation, which is going to, you know, dissipate into the ether after 5 minutes, you know? Oh, I don't really remember what we were talking about. Yeah, it was a 6-hour conversation. Don't really, on a Sunday, don't remember. Yeah, like, so the duty to document is really important. And there are some jurisdictions that are really pushing the duty to document. New Zealand is one of them. BC's Freedom of Information and Protection of Privacy Act has a duty to document. There are questions around how sort of actionable this duty is. I think, you know, one of the tensions is the moment someone knows something's going to be disclosed, they are thinking of how to not disclose it. So what you need to do when you use the system is think about novel ways to get information from the government, right? So this is where asking for information gets so much fun. I feel like such a nerd as I said that. I feel like I have like a very unwatched YouTube channel somewhere deep in the internet. I'm like, guys, I'm like Twitch with like 1 viewer. No, but it's serious because it's, you know, the state of news these days is just garbage. And so I think thinking of how you can actually get information that's relevant to your interests or your work, you know, it can yield really interesting things. And I've had a lot of ATIPs that have just gone absolutely nowhere. And then I've gotten a few that I'm like, this is great. So there are a few different ways I encourage you to approach the system. And one is to sort of, when you're reading the news or when you're working your area of interest, like think of the issues that are kind of underneath. Think of sort of what the government might actually have in its possession or have under its control that might be a record that's pertinent to you. And then add sort of other sort of dimensions to it. Think about who are the people that you're interested in getting records from, right? You might want to narrow sort of the scope of the request to specific people, right? I put in a request recently for one individual, and I used their email, and I said, I want all emails from this individual that have been sent to this very small government entity. But it was one email, so all it requires is a quick email search. And I kind of crafted it because I knew it would be easy to complain about too. It's something I'm trying to argue with Professor Sykes about regulatory capture in the Canadian Transportation Agency.
You're not arguing with her, you're together arguing.
We are together arguing as one. Yeah.
I get to see a cage match between the two.
Right. She would win. Let's be real.
No comment.
Yeah. Let's be real. I'm down. And then also think about sort of timeframes. Timeframes can also produce really interesting things. I put in an access to information request around studies that have been done around the Emergencies Act, but I specifically put it in a period that was sort of way in the past, because I just want to see how the government was actually thinking about using this act. So sometimes really applying specific periods can be interesting. Thinking about document formats can also be fascinating. You know, if you're trying to get something, you know, send me all documents in this particular file type. There's an obligation under Section 4 of the Act. Section 4 is the section that creates the right of access, but there's an obligation in there that says the government should try as much as possible to give you the document in the format that it was in. And that's a really interesting obligation, because if it's in the format that it was in, it might have things like metadata, and you might be able to do things with it that are really interesting. Tom Cardozo at the Globe and Mail obtained all kinds of Excel sheets from Correction Services Canada that had sort of really interesting data around how racialized people were being treated in the system. He published a series of articles on it that were really hard-hitting in 2020. He won Journalist of the Year for it, and it was all based on sort of extraction of metadata and sort of proving systemic racism within the correctional system. It was really, like really interesting research. If you're curious about how to sort of write requests and things like that, I would sort of recommend by starting start with the system itself. So opencanada.ca is the government website. This is the government website where the government will have a lot of proactive disclosure already on this website, along with summaries of requests that were previously filed. So here you see the proactive disclosure. This will contain things like information about the briefing notes that I was mentioning, contracts over $10,000, grants and contributions. So professors, if you're getting money from the federal government, it is going to be disclosed. But some of this stuff is disclosed automatically. Same with travel and things like that. Probably due to past scandals about how money has been spent, and there's been sudden agreement to reform the act. So the briefing packages will often contain sort of interesting information, and based on what the titles sort of tell you, because there's nothing more than just sort of the title. So newspaper journalists will frequently seek requests through there. Another way to approach the system, and this is something I quite like to do, is I like to noodle around on completed requests. So if you look at requests that the government has actually completed, they don't make them available. What they do is they make a summary of the request available. So you've got information here like the specific federal institution, when the request was made, and you can search within this. And I'll give you just the example I was doing last week. So I did a search for ransomware, because I wanted to sort of see what federal institutions were the victims of ransomware. So you get all these hits of past access to information requests that sort of include your search term. You'll see on the right if there were any records disclosed. It says 0 pages, so there were no records disclosed. Trying to find the one I used here. It's this one, yeah. So this is a really, this is the tip that I originally started with when I was using the system. Is I basically like to just take the language of requests that have been successful, and I like to kind of finesse them into my request. So I saw that this request was successful in getting 5 records, but it was only through to July 20th, 2021. So I just put in the exact same request, and I said, give me all records from July 21, 2021 to the present. So now, and I got the record really quickly, because the privacy commissioner is one of the best for access to information, as you might expect. And so they disclosed the record to me. One thing I will say about this is the big project I've been working on for like a couple of years now. This is called an informal request. So everything that I've been describing under the Act pertains to formal requests. So when you make a formal request under the Access to Information Act under Section 4, you have the rights that I was sort of talking about with Rob, right? You have the rights vis-a-vis the Information Commissioner. You have the rights to seek judicial review. You alone hold those rights. When the request is filled, the record will go out to the person who filed it, whoever that is, but it's not disseminated in a more public fashion, right? It's not disseminated unless that person takes the record and then puts it on a website somewhere or shares it with people or whatever. And this kind of goes to this really interesting question that you had about, does it matter who's filing the request? Because like, what's to say I'm not the government of China filing access to information requests. I mean, that informs one of the reasons why we have public interest against disclosure, to be sure. But those are all sort of formal requests. When you come to this informal request, the government has currently provided these summaries, but it hasn't actually disclosed any of the records. And so what I've been doing for the last 2 years is I've been collecting completed access to information requests. And I've been doing it because there is a 2-year retention period by the government. So the government Connor puts in a request to me, and I'm the government and I respond to him. I retain a copy of that record for 2 years. That's what the current policy says. And after 2 years, I can put it in the shredder and it goes away. And so there's so many records that are being actively deleted every single day, right? And if you go back, you can sort of see, how many requests. Let me see here. Oh, this is it's just the 18 search. But if you go back, you can see like the number of requests that'll be, yeah. So there's about 40,000 over 4 years here. So about 40,000 requests. So, and every 2 years, that's about 10,000 a year. So every 2 years, you've got, 20,000 records that are being actively deleted. And to me, the harms that creates, or maybe not talk about it in terms of harms, but the research potential that's being lost. There's test data that comes from Health Canada that could be useful to researchers. There's all kinds of stuff that could be useful to you in your research. So something that I've been doing is I've been spamming this website to obtain the records before they get deleted, right? Going backwards from when the records are deleted. And the government, I've been doing it for years now, and the government's been sending them to me. And I currently have about 11 to 12,000 records, which are saved on a Dropbox. And this is a project I've been working on for quite a bit of time, but something I want to do down the line. It's more than I know of being publicly available anywhere. But down the line, if I can get a research grant, I'm going to write a policy paper on reforming that practice and making those records publicly available, and in the form of some kind of policy brief. And when I go forward with that policy brief, I want to publish the database as well and say, here are 12,000 reasons why you should publish these records, because any of them could be valuable to your research, right? I have like, I don't know, I got 74 records from National Defense this morning. So there's so many records that could be relevant to researchers, to parties that could use this information in really unanticipated ways. And so, yeah, so that's been a project that I've been working on for quite a bit of time. Yeah.
I was just going to say, it really pays to be a nerd about this kind of stuff. My goodness, you sort of built like a whole world of research and interest here.
Well, it's kind of interesting because I am only glimpsing the possibilities of how the research could be used. Like I have a friend who is in Toronto, who's doing all kinds of sort of research and activism around trans issues. And, I've been getting access to information requests from the Treasury Board Secretariat because of spamming this website, which include really detailed discussions around sort of internal government decision-making to put pronouns on signatures or not. And like research that's just like totally not in my field. And I'm like, well, this is interesting in itself, but I don't have time to read 500 pages. And just sending it along to someone who I just happen to know is working on something in that area. And the response I've gotten, the uptick I've gotten has been huge. So the inclination that I have is I really want to disseminate the records to as wide an audience as possible, because I'm putting them in a Dropbox that I pay for with my research funds, and it's like 200 gigabytes of just government data on that website. But I want to make it publicly available, but I want to do it only at a point where I can sort of go to the Parliamentary Committee on Access to Information Privacy, and basically make an ethics and make a proposal to them that says, these records, you should create a legislative obligation to retain these records and disclose them. I think there's so much research potential that's being lost in actively destroying the records. Yeah. No.
So there was another question.
Two questions, really quickly. So if I were a litigator, or if I had an idea for a research paper, and I made a request. It's the general time frame you want, or is it just so various that you can't say? So that's one question. Can you say more about the idea of either the provisions of the end or the principles you involve to justify access to a specific piece of information pertaining to one actor within an entity? That's an intriguing idea. I'm assuming that's news for all.
Yeah, so the first question is the time question. It's a really interesting question. I can give you an idea of some statistics around time that'll be helpful. So it's the general rule is it's 30 days for both the Access to Information Act and the Privacy Act. So last year there were about 40,000 requests that were closed. So there's requests that are received and requests that are closed. There were about 40,000 that were closed, and 70% of them were closed within a legislative timeline. So that means 7 out of 10 were closed within 30 days.
You get the record in 30 days.
Well, that's 40,000 requests in 1 year. This website shows about, last year there's 14,000 requests that are summarized. So a good chunk of those records are probably no records to disclose, or you're hitting up the wrong ministry, right? Which is something they love to do. They love to put in a request to ISED and then, sorry, not us. And you're like, well, why didn't you tell me like 40 days ago when I put in the request, right? So those numbers are probably, that 70% is probably inflated. I started using the system when I was writing about trade secrets, as I was saying, and one of the ways I was really interested in sort of naively using it was to put in requests to the RCMP and the Public Prosecution Service of Canada surrounding a new criminal provision pertaining to trade secrets that got passed, Section 391. And that request took, I think, 450 days.
So they answered you within 30 days if they got the request.
So they'll always get back to you. I mean, and if they don't, you should complain, but they will always get back. That's a deemed refusal, but they'll always get back to you and say, we'll process your request in 30 days. And then at the end of the 30 days, and they will always wait until the 30th day, they will send you an email that will say, due to the need for consultations with the other government institutions, or because of interference with government operations, we need an additional X. And because they can only send one delay letter, it'll say something like, 5 days, 87 years. There was a reporter at Global News who got one that said 87 years when he put it into the RCMP. It's like it's just bonkers stuff. So yeah. So, but the timeline question is really interesting because it's really dependent on the unit, right? Like some of the units are really, really good. The Privacy Commissioner is excellent, right? The Office of the Information Commissioner, excellent. The Treasury Board Secretariat, which sets policies for how government operates, good, right? Infrastructure Canada, which has all kinds of sort of juicy details on these sort of big government handout projects. Their ATIP unit is fantastic. But then there are some that are just like evil. I can't think of a better word to say it, because they actively stymie what the legislation seeks to do. And so I think of things like the Privy Council office, which is basically as close as you might get to the PMO. I think of the RCMP, but I would say the RCMP is just understaffed. And for the most part, I do think that the Access to Information officers operate in good faith. They're trying to do their job, but they're really challenged between sort of the different forces that are pulling on them, right? They're also, these units have also been shrinking over time, right? One thing that's a little concerning personally is the degree to which the Access to Information system itself has been experimented with using contractors. There's been a lot of news recently around the role of government role of contractors like McKinsey and Deloitte and Accenture, and it's been all over the news. One of the reasons why using consultants and contractors is so favored is because when you're the government and you contract with a party under the Access to Information Act, those contracts enjoy no protection, right? There's really clear jurisprudence that if I am the government and I contract with Brad to perform some kind of service, the contract that between us has no expectation of confidentiality. And there's a lot of jurisprudence to support that. And so when you file a complaint saying, I want the contract, you're likely going to get it. But the reason they like to use consultants and consultants is because when the consultants subcontract, those subcontracts are protected as confidential information and trade secrets. And so that's really what the issue is with parties like McKinsey. They're basically spending money on behalf of the government to provide services to the government, but the service that they're actually providing is secrecy, right? Because those third-party contracts are not subject to disclosure. So that's, to me, that's really concerning. It's concerning as well because it folds back into how the access to information system operates. The government's increasingly using consultants themselves to deliver services. KPMG has been very active in pitching sort of the use of digital ID to replace some of the identity verification processes that the access to information system uses. One of the companies that was embroiled in the ArriveCan scandal, a company called GC Strategies, has actively pitched using artificial intelligence to make access to information requests searchable, which in theory is a good idea, but the idea that it would be subcontracted or contracted to this company who would subcontract to other actors and none of that information would be disclosable is deeply concerning. The second question that you had about seeking information from specific parties, it's interesting. Under the Act, so there are all different kinds of exemptions, and there are exemptions and there are exclusions. And something that is exempt from the Act can essentially be challenged, right? So there'll be a redaction, and you can have a conversation with them about whether it actually truly is subject matter that is of the nature that the exemption provides. If it's excluded, the information commissioner won't even be able to see the record, right? So something like cabinet confidences, which are excluded, the information commissioner won't even be able to look at those. So once they're invoked, it's ironclad. The most common exemption that is invoked is personal information. There are certain exemptions that you see a certain uptick. Law enforcement is one of them. But all of the exemptions, in addition to being subject to the information commissioner's reviews, all of the exemptions as well, especially the third-party exemptions, have some kind of public interest principle that operates over them. And the third-party exemptions are the most interesting for that. Again, sort of one of the ways in which I got really interested in the Act is that the only subject matter that is not subject to the public interest override in the Access to Information Act, third-party records, are third-party trade secrets, which I was just like, why did that get put in there? So, yeah. But thank you. Yeah, great questions. And if that answers everything, I'm going to do more. Yeah. Brad.
For a third-party contractor to the government, while you may be able to access the contract, and you may be able to access any reports provided by the contractor, but can you access any of their kind of raw material?
For third-party contractors?
Yeah, from the third-party contractor, all the research notes, et cetera, everything they got together.
Yeah.
That underlies the report that they provide to the government that you may get non-redacted or redacted, as the case may be.
In my experience, no. And that was the experience I had with the trying to seek disclosure of material related to the ArriveCan app. So ArriveCan, was like a $50+ million behemoth. And the main contracts were through 21 principal companies. And I obtained all of those contracts when I put in my request for them and complained vigorously about them. But ultimately, I got nothing useful because all of the really interesting stuff were in the subcontracts that had been created with other third parties. And so in my experience, the answer to that is no.
But what about even with the primary contractor? So there may be subcontracts you don't know about, but the documents created by the primary contractor that don't go into the product they give to the government of Canada, but government of Canada is paid for through research, staff work, etc. Is any of that accessible because it's been paid for out of federal funds?
It's a great question. So, and it turns on whether any of the information is susceptible to an exemption under the Act. So there's different kinds of exemptions like law enforcement and, you know, trade secrets and whatever. And in my experience as well, it really turns on what those companies would invoke. I mean, most commonly, they're going to invoke some kind of economic interest in keeping the information undisclosed. And those types of, invoking those types of arguments generally tends to be persuasive.
So the Act does apply to those contracted parties, including then exemptions.
Yes, you would be able, in theory, you can ask for, if it's a main contractor with the government, you can ask for their information pertaining to the program or the activity. Yeah.
And presumably the government then goes to the contracting party to obtain their response, et cetera.
They have some sort of conversation.
Yeah.
Yeah, it takes a while. Yeah, I mean, one of the reasons why it also slows down too is anytime they're thinking about invoking these exemptions or anything that they see sort of the nature of a lot of the obligations in the Access to Information Act are that if it sort of prima facie triggers the exemption, then that creates a burden on the part of the ATIP officer to do these consultations. So for example, if I ask Colton for records relating to X, but the records include emails that you have sent to Colton, which might be disclosed as part of the overall disclosure. What the ATIP officer is obligated to do if they think that any of the information in those materials triggers an exemption is reach out to you and ask you if that's the case, right? And generally what happens, especially for third parties that are, you know, don't want any kind of, that, you know, that favor opacity, that don't want any kind of transparency, at that moment, they will usually come alive and make really strong representations. Like everything in here is solicitor-client privilege, everything in here is a trade secret, everything, you know, and they'll come very strong. And if the information commissioner then comes back, or sorry, the ATIP officer then comes back to them and says, I've received your representation, but I believe that this does not fall under the this exemption, and so the record will be disclosed. That party has the right to seek judicial review of the ATIP officer's decision. Yeah, and that can, I mean, probably the most impactful access to information case in the last 20 years, which is the Merck Frost case, stemmed from just that, right? There was a researcher at the University of Ottawa, or I believe he was at the University of Ottawa, but he was trying to get a data set that belonged to Merck Frost, which was under the control of Health Canada, which had been disclosed as part of a regulatory process to approve a drug of some kind. And he tried to get the data set from Health Canada. Health Canada had to notify Merck Frost that it had this and was going to disclose it, but thought, well, there might be something in here that's a little bit. Merck Frost immediately sent its lawyers and sued Health Canada. So the case was Merck Frost versus Health Canada. So, and that's interesting in itself because the complainant is not present in any of that process, right? So like the requester. So the reasons for why they requested the information are completely muted, right? Like the public interest that the request might have served are completely muted. That to me is really, really interesting. It does a disservice to access to information.
You also don't have to spend the tens of thousands.
Yeah, but even if they went as an intervener, they might be susceptible to paying like Merck Frost disbursements. You know, it's shocking. So anyway, sorry. Yeah, you had a question.
To what extent has like, you know, sort of the culture of like the WikiLeaks and the Snowden sort of reveals of information affected these institutions, at least in Canada? Like, I can't sense that this is sort of like the approved pathway, and not that you're going to go like hack into the mainframe of like the federal government. But
I couldn't do
like,
it if I wanted to.
I think that's the other sort of tension that I think I've seen, at least in this space. It's just that there's also like a desire to make everything as open as possible in the spirit of sort of radical transparency and accountability. But that in and of itself, I think, to the points you made about reasonable protections that the government deserves to have against certain information being
Absolutely.
How does that sort of interface with this system, at least you've been using it in the past few years?
It's such a good question because it goes to sort of broader, it engages a lot of things that I actually spend a lot of time thinking, because this is all a side hobby. ATIP is sort of a means to an end. And I do encourage you to use it in that respect. But it goes to sort of broader questions around secrecy that I think about a lot. Like, why do we protect secrets, right? And sort of what are the nature of the different types of interests that actually subtend what those protections are, whether they're privacy interests or whether they're economic interests. And I think something that I constantly think about is the way in which notions of the public interest sort of inform all the discussions we have around why we protect secrets and why we don't protect secrets. And you can see it happening even now with the conversations in response to the disclosure, the really intense disclosures that have been happening in the Globe and Mail around election interference. This new one today that CSIS has, something about the Pierre Elliott Trudeau Foundation and so forth. And, you could certainly go to the Pierre Elliott Trudeau Foundation and ask them for information. I've definitely done that in response to some disparaging comments that were made about foreign influence of the convoy. I was like, let's think about foreign influence. So I actually put in an access to information request to the Pierre Elliott Trudeau Foundation last February that said, please provide nothing more than a percentage of how many of your donations are foreign donations versus domestic donations. And I found out that most of the donations were foreign. So, I said that to several journalists and I was like, this is kind of interesting, no? And they were like, not relevant. Like, I know, I'm just some like random grad student. So,
Did they have to, or did they just provide that to you?
so they're subject to the Access to Information Act under Section 3. So institutions as well as under the Harper government, Crown corporations and foundations were made susceptible to the provisions in the Act. But your broader question is really interesting because I think about these questions a lot in terms of how what's really determining the boundary between what we consider secret and not secret is one that's informed by what the public interest is, right? I wrote about this in the context of doxing that occurred around the convoy. There were a lot of really fascinating examples of doxing that were occurring on all sides of things, right? People were doxing the truckers, people were doxing someone doxed the prime minister, released his private schedule, which is really concerning and a really egregious sort of breach of, there's criminal prohibitions against breach of trust by public officers. So certainly susceptible to criminal liability. And there were other examples too. CBC wrote some articles using the hacked Give, Send, Go data. But in all of these contexts, whether it's whistleblowing or whether it's doxing or whether whistleblowing as in the Edward Snowden examples that came up, WikiLeaks, or even whether it's present in sort of how the access to information system operates and what we consider should be disclosed and what shouldn't be considered disclosed. And a lot of these are intuitive categories, right? Public safety is something everyone loves. So of course we wouldn't want to disclose something that would threaten public safety. But all of this is being informed by conversations around the public interest. And I think those are conversations that we need to have in a more explicit way. And I think we could look at jurisprudence in Canada around things like sealing orders, which really talk about sort of why we have confidentiality in judicial contexts in a rather sensible way, right? They talk about weighing the public interest in disclosure against the public interest in non-disclosure. The Sierra Club judgment has some really good conversations about what those public interests are and what isn't a public interest. And I think the moment we start to think about that part of the law in a more proactive way, we see that that's actually what's going on here, right? Whenever we sort of see, whether there's actually a public interest in this type of disclosure, I think that's when we start to reckon with where the real boundaries are. The example that also comes to mind is the Ashley Madison breach that occurred a few years ago, where a lot of prominent figures were caught in that breach and had their personal information disclosed. And one thing that I saw, and I think it was a very heartening thing to see actually, is that there was a lot of restraint by journalistic entities and so forth in terms of actually publishing and not publishing certain things about the breach. And I think that was a really good impulse on the part of our journalists. The problem that amplifies it now is that everyone is a journalist because of Twitter. So now everyone gets to make these decisions around what is in the public interest and what's not. And so the moment I have embarrassing information about Justin Trudeau, I get to determine the public interest and release the information, right? And that's injected a lot of extremism, I think, in both respects, because you have people who exercise sort of judgment about the public interest that is very poor judgment, but it has, on the flip side, encouraged an exercise in terms of the Access to Information Act and other forms where you see zero inclination to provide disclosure. And so I actually think a lot of these conversations are amplified by technology, but underlying it, for me, what's really going on are questions about the public interest that we have to think about. And it's incumbent on all of us, because as we all think about what our actual privacy rights are, Rob knows I've just written something about this, like all of these things are something that we sort of negotiate and then renegotiate, and over time what we're comfortable disclosing about ourselves changes, and we constantly negotiate that vis-a-vis the public and exerting control over that type of information. I'm thinking about just the person as the unit here, but you could extrapolate the same commentary to governments. It's really interesting. I mean, it changes over time. And that's why every time you see a new government elected, there's always these promises of renewed access to information, right? Like whenever you look, it's actually super funny. Whenever you look at like government reporting on access to information, you'll see like, you know, record high non-disclosure, and then there'll be like an election with like a new majority government. And then you'll see like a slight dip where it's like, oh, they're starting to disclose. And then after like 2 years, you'll see like record high non-disclosure. And it's like, over time, I've done a lot of graphs over like 10, 20 years, and it's always humorous because you're like, oh, that was an election. Oh, I remember that election. Yeah, I remember voting for that person. Yeah, it's kind of funny. But, yeah.
Well, I think we should probably wrap up. Do you have maybe a final word for anybody who is like intrigued and wanting to maybe start doing this?
Anyone who wants to file access to information requests, I'm super happy to work with you. I'll pay for them as well. I pay for them out of my grant, and I'm very keen on it. And I think it's a super good skill. So I encourage you to engage with the system a little bit. Another place to look for good questions that I haven't raised here is the House of Commons order paper, written questions. Some of those, I mean, that's like access to information on steroids, but there are a few really good questions. Some members of parliament definitely ask good questions, so I sometimes use that as well. But I encourage you to sort of engage with the system, file questions. I'm happy to work with anyone who wants to do that. I would be happy about that. And if and when I get a grant and can do this policy work on making informal request open by default, I will definitely put out an ad for that. So yeah, for research help. So
right. Well, let's thanks, Matt, for a really interesting presentation. So we still have some food and some drinks. Feel free to kind of loiter around for a little while. And then also just a heads up, our next and final research series event will be March 21st. Professor Fair, it looks like he had to go off to teach, will be giving a presentation at that time on criminal defenses, which is really fascinating. So thank you all so much for coming, and I look forward to seeing you next time.
Claire, thank you.
Thank you so much.
Yeah.